What's going on? I wonder if he can see us. If he could, he can't.
Yeah, the squirrel will be in AC.
Thank you. Wire, are you all set to handle Mr. Russell?
I am all set to handle Mr. Russell.
Okay, great. I think we're getting the judge now. Go ahead again.
Dan, Frederick Bragdon with the Bennington PD. Can you hear me? I can hear. You're muted.
I can hear you and I can see you, Mr. Bragdon. Do you have a bow tie on today?
Always. I need to call you about Mr. Russell. He is a defense witness in a felony matter of mine, where he has written a statement to the police supporting the defense.
This Elliot Russell? There's
This
two of them.
Elliot. There's Mason Snike. There's Elliot and there's Marion.
So
That's Elliot.
give me a shout, we'll talk.
Yeah, I don't want to stir the pot too much. I understand what he's charged with. Luckily, there's a second person who is also a witness at the same time and wrote a confirmatory statement. So I may not have to torch you too much, but I'll reach out to you at some point. But that's why I'll be reaching out.
Always an open door, Mr. Bragdon.
Thank you, Dan.
Yep, you bet.
He is a.
My heart is pumping so fast. I should beat in that heart. We can't hear him at all. If he's talking. I don't know who he's talking to. I see his mouth moving, but we can't hear him. It's crazy. They muted the courtroom. Look at the judge. Oh, she coming. McDonald. Somebody. I hope just the lady, because that man judge, he gotta go. So I was trying to get her name before.
All rise.
Thank you. Good afternoon. Good afternoon, everyone. Please be seated. I just need a moment to just reset my computer here. So good afternoon, I'm Judge McDonald Katie. So we're here on the record. This is docket 22CR-10081. It's State of Vermont versus Elliot Russell. We have Deputy State's Attorney Bianchi here in the courtroom. Mr. McGuire is here participating remotely, and Mr. Russell is also participating remotely from the correction facility. And Mr. Russell, I want to make sure that you can hear and see the court. Mr. Russell, I just want to make sure that you can hear and see the court before we go on with the hearing.
What? Yes,
I can't hear Mr. Russell, although it does look like he can hear the court. Mr. Russell, very good. See the court?
Yeah, right.
Very good. Mr. McGuire, I just want to make sure that you had an opportunity to speak with Mr. Russell before the court came out on the bench.
Judge, I've had an opportunity to speak with Mr. Russell, and we'd actually spoken some time ago when he was in New York. So, yeah, we're prepared to go forward today if the court is ready.
I am. So, in this case here, the court did find probable cause for the one-count criminal information of second-degree murder. The court did find probable cause on October 28, 2022, based on Detective Briggs' affidavit. And Mr. McGuire, are you in receipt of those two documents on behalf of Mr. Russell?
Judge, I am in receipt of the state's information dated October 28th, 2022. The affidavit in support of probable cause by Detective Corey Briggs, and also a supplemental affidavit that was provided to me or my office. Also Detective Briggs from December 7th, 2022. Without further reading and waiving the 24-hour rule, we'd like to enter a plea of not guilty.
What?
We've had the opportunity to speak with the state. They're going to ask for a hold without bail. At this point here, we'll concede to the hold for the purposes of today, recognizing that if we want to test the weight of the evidence as the discovery comes in, we'll ask the court to set up something.
Okay. Mr. McGuire, very good. So we'll enter the not guilty plea on behalf of Mr. Russell here. And Deputy State's Attorney Bianchi, with regards to the state's request, is it that Mr. Russell be held without bail under 7553?
Yes, Judge, we are asking that the defendant be held without bail under that statute. We would further ask for condition 14 and 15 regarding Aaron Wilson. And at this juncture, that would be the scope of the conditions that we're seeking. But there may come a time where we file a motion for additional 14 and 15 contacts.
So, Mr. McGuire, with regards to the state's request that Mr. Russell not have any contact nor abuse or harass Aaron Wilson, your position about those conditions of release?
They're concerning for us only because that is his paramour, his significant other, person in his life, Aaron Wilson. He's represented to me, Judge, that she's pregnant with his child due in July. And so conditions could indicate that he's not to discuss the case with her. But a prohibition seems unfair and also not necessary, given that I assume that statements have been taken in this case already. Be that as it may, Judge, thank you.
State's Attorney Bianchi.
As the court may be aware, Ms. Wilson has also been charged as a defendant in this matter as an accessory. So the condition is necessary and appropriate to protect the public and also to protect the integrity of the adjudicative process. So we do ask that a no contact and a no abuse and harass with respect to Aaron Wilson be entered.
I just want to look up a docket here, so I just need a moment. Okay. So the court has entered the not guilty plea here. The court will issue a hold without bail under Title 13, Section 7553. It is not contested here. Mr. McGuire at least is consenting on behalf of Mr. Russell the hold without bail pending his request for an evidentiary hearing related to the evidence of guilt being great, as well as any conditions, release, or bail that the court can impose if it exercises discretion under Title 13, Section 7554. Based on the seriousness of the offense here, that the court had found probable cause that Mr. Russell, in fact, committed the offense, the court does find that the hold without bail is appropriate, a life imprisonment offense. With regard to the conditions of release, Mr. McGuire, I pulled up docket number 22 CR-10084, that's State of Vermont versus Aaron Wilson. The co-defendant here, she's been charged with accessory. In this case, there are conditions of release that the court imposed on Ms. Wilson, including a 14 no contact with Mr. Elliot Russell, which continues. Those were imposed back on October 31st, 2022. So at least here, Ms. Wilson would not be able to have contact with Mr. Russell, even if the court allowed for contact, meaning not impose a condition number 14 or 15 here. But given the significance of the case and that she's a witness as well as a co-defendant, the court does find appropriate, at least right now, of imposing the no contact provision, including the no. And I'll leave it as a no contact provision 14, which reflects Ms. Wilson's no contact. I won't impose the condition 15, no abuse or harass. It's simply no contact at this point. Mr. McGuire, I can see a motion potentially filed in the future to modify that, although again, it's not simply just modifying this condition because Ms. Wilson has a condition 14 that she can't contact Mr. Russell. But the court does find that to be the least restrictive conditions here. With regards to the conditions, they are co-defendants. Ms. Wilson is also a witness in this case here, and the court does find appropriate that the party should not have contact, at least right now, even pending. I don't know whether or not there are further statements here. Certainly there are statements that Ms. Wilson made reflected in the affidavit of Detective Briggs, but the court is going to impose that. Condition 14 is finding it the least restrictive condition here, and it goes to protect the public, which Ms. Wilson is part of that public. So, Mr. McGuire, I won't set this for another hearing. I'll wait to see if you are requesting a contested weight of the evidence hearing, but as far as status conference and calendar calls, do you want the court to set a status conference right now, or would you prefer for the court to base that on a schedule, based on a felony discovery schedule that you and the state agree to? I can just set this out for a status conference in a certain amount of days pending that discovery order, or?
Judge, we can probably get you a discovery order within 14 days.
Okay, all right. And Deputy State's Attorney Bianchi, that's agreeable to you as well?
It is, Judge, although if we could get 30 days, that would be ideal, because I think that probably will be looping in Attorney Strecker, Aaron Wilson's defense attorney, to try and coordinate this as a shared schedule.
That's fine, thank you.
Okay, so we'll look to have that felony discovery order within 30 days. And Mr. McGuire, when you're requesting a contested weight of the evidence here in the court, will set that and issue a transferred order so that Mr. Russell is present in court for that hearing. But in the meantime, the court will issue and continue that order, that hold without bail order here.
Understood, Judge, thank you.
Okay. So Mr. Russell, the court will set those conditions of release. We'll send a copy of those to you, and those will be in effect starting today, meaning that you can't have any contact with Ms. Wilson, at least right now. That includes, even if you're incarcerated, that you couldn't send a message to her, whether directly to her or even through a third person. That would be a violation of the court order of no contact.
I understand.
Okay. All right, very good. Mr. Russell will be in recess on your case then.
Thank you. Thank you, Mr. Bianchi. I'll be in touch, Mr. Russell.
Thank you, Attorney McGuire.
So I guess that means that.
What?
I said I'm guessing that means you can't hear me.
Yeah, I hear you now.
I guess that means that, you know,
What?
they recessing his case. Like, they going, he got another court date coming.
Yeah.
So,
Oh, that shit was gonna be over. This shit went on for a minute.
yeah. He pleaded not guilty. Of course he did.
I know. I heard that. Mm-hmm. He can't have no contact with old girl.
Mm-hmm.
They about to smoke his boots.
Yeah, they are. And I hope so. Because mind you, the detective...
Pretender. I'm glad Pretender got me thinking and can get off.
Okay. Facts. Because, the freaking... This, I'm just stuck right now, like, a little bit. I don't know why I'm stuck on this shit, like, this shit had me a little bit emotional, but I know, I'm trying to get it together right now, like, alright, so just bear with me. Yeah. Well, right. Exactly, and it seems like, you know, we got a good chance on getting this and winning this fucking case, because we gonna win this shit. Like, period. Like, we definitely, and I see that, my thing is, like,